attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the first in a LawCast series talking about the latest guidance from the SEC on cryptocurrencies as a security. On June 14, 2018, William Hinman, the director of the SEC's Division of Corporation Finance, referred to as CorpFin, gave a speech at Yahoo Finance's All Market Summit in which he made two huge revelations for the crypto marketplace. The first is that he believes a cryptocurrency issued in a securities offering could later be purchased and sold in transactions not subject to the securities laws. The second is that Ether and Bitcoin are not currently securities. Also, for the first time, Hinman gives the marketplace guidance on how to structure a token or coin such that it might not be a security in the first place. While this gives the marketplace much needed guidance on the topic, a speech by an executive with the SEC has no legal force or effect. As a result, the blogs and press responding to Mr. Hinman's speech have been mixed. Personally, I think it is a significant advancement in the regulatory uncertainty surrounding the crypto space and a signal that more constructive guidance will soon follow. I will summarize the entire speech later in this LawCast series, but first right to the most salient point. Although a speech by an SEC official does not have legal weight, it does give practitioners a firm foot on which to proceed. William Hinman is the director of the Division of Corporation Finance, whose responsibility includes reviewing and commenting on SEC filings, a topic I've covered before. When responding to SEC comments, a company may go up the ladder, so to speak, in its discussion with the CorpFin review staff. Such further discussions are not discouraged or even seen as an adversarial attack in any way. For instance, if the company does not understand or agree with a comment, it may first talk to the reviewer. If that does not resolve the question, they may then ask to talk to a particular person or the person who prepared the comment, or directly with the legal branch chief or accounting branch chief identified in the comment letter. A company may even then proceed to speak directly with the assistant director, deputy director, and even the director. Related to Bitcoin, Director Hinman stated, "When I look at Bitcoin today, I do not see a central third party whose efforts are a key determining factor in the enterprise. The network on which Bitcoin functions is operational and appears to have been decentralized for some time, perhaps from inception. Applying the disclosure regime of the federal securities laws to the offer and resale of Bitcoin would seem to add little value." Similarly, related to Ether, Mr. Hinman stated, "Putting aside the fundraising that accompanied the creation of Ether, based on my understanding of the present state of Ether, the Ethereum network and its decentralized structure, current offers and sales of Ether are not securities transactions." As a direct result of these statements, at least two of my firm clients, with our support, have shifted how they will proceed with Regulation A offerings in which tokens are being offered and Bitcoin and Ether expected to be accepted as a form of payment. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.